I totally agree with the fact that marriage is a sacred institution, not because it is what the Bible said it is. What made marriage sacred is because it is what the custom of the people said it is, or it is what the state said it is. It is not because the Bible is sacred, then marriage too has to be sacred. No. In fact, marriage is older than the Bible. Marriage is older than the Bible. And marriage is older than Christianity. Marriage is older than the Bible, and marriage is older than Christianity. Christianity started 2,000 years ago, but marriage has been in existence before 2,000 years ago. In fact, the Bible even recorded that Jesus Christ, whom himself is the founder of Christianity, attended marriage during his lifetime on earth. Jesus Christ attended marriage. And that is why we say that marriage is older than the Bible itself and older than Christianity itself. Welcome to today's edition and continuation of our series, The State or the Church, Who Regulates Marriage. Thank you so much if you are just joining me today. Please, you can do well to look at my previous videos. I've done part 1, part 2. Today's video is part 3 of my book commentaries. Previously we've been looking at the marriage contracted at licensed places of marriage, and today we're going to expand it a little bit further to look at the other categories allowed by the Act. So today we'll look at the fact that Marriage Act recognized 3 categories of marriages. The Marriage Act recognized 3 categories of marriages. Number 1, we have the marriages at the registry. Number 2, marriages by special licenses. Number 3, marriages in places of worship authorized for that purpose. We have been looking at that for quite some in the first chapter and the second chapter. So in this 3rd chapter, we're going to look at focus on marriages at the registry and marriages by special license. What is it all about? So as an individual or as a couple to be, you can choose any one of the above recognized categories to contract your marriage. Any one of the above categories is a recognized means of contracting marriage under the Marriage Act. So far, we have discussed extensively on marriages in places of worship licensed for that purpose. Marriage at the registry usually commenced with one of the parties intending to marry issuing a notice to the registrar as in Form A of the Act. Now, anyone who wants to contract a marriage at the registry will usually start by issuing a notice to the registrar. Okay, we're talking about marriage at the registry. If you want to get married at the registry, now we're not talking about the church now. We're talking about someone who wants to get married at the registry. What you will need to do first is to issue a notice by informing the registry that, okay, I want to get married at the registry. That's the first thing you do. Issue a notice to the registrar as in Form A of the Act. The registrar, upon receipt of such notice, is expected to enter it in a book called the marriage notice book. So upon you giving the registrar notice, the registrar is expected to enter your notice in what we call the marriage notice book. The registrar, upon receipt of such notice, is expected to enter it in a book called the marriage notice book. The registrar also is mandated under the Act to leave a copy of the notice outside the door of his office until he grants his certificate or for a period of 3 months. Now, after you have given notice to the registrar that you wish to conduct your marriage at the registry, the registrar is to enter that notice in a book called the marriage notice book. After he entered that notice in the marriage notice book, he is expected to take that notice you issued to him in Form A and paste it at the door of his office or at any other location within his office that is open to the public, until that notice will remain there until he issues you the marriage certificate or until after the expiration of the period of 3 months. Okay. So the registrar is also mandated. Okay, we have said that. The marriage is expected to take place after 21 days upon giving the notice as in Form A and before the expiration of the period of 3 months. So after you give notice to the registrar, you are expected to come to the registry and conduct your marriage after 21 days before the 3 months. So after 21 days, you are supposed to come and conduct your marriage. So after 21 days, you have till before the expiration of the 3 months to come and conduct your marriage. So you cannot conduct your marriage before 21 days after the notice. You can only conduct your marriage at the registry after 21 days and before the expiration of the 3 months. You understand that? Okay. So where the parties fail to contract the marriage after the expiration of the 3 months notice, a fresh notice as in Form A must be issued to the registrar for that purpose. So if you fail to contract your marriage after 21 days or after the expiration of the 3 months, you can no longer contract your marriage under that notice. A fresh notice must be issued for you to be able to contract the marriage. So after you issue the notice to registrar that you want to marry at the registry, you have after 21 days, you are supposed to come and conduct your marriage. So between that, after 21 days to the expiration of the 3 months, if you did not come to the registry and conduct your marriage, that means you need to issue a fresh notice. That means that notice has expired. After 3 months, you can no longer conduct your marriage until you issue a fresh notice for that purpose. The marriage notice book kept by the registrar is open for inspection for the public at no cost within the office hours. Okay? Now, any person whose consent is required or who may know any just cause why the marriage should not take place can raise an objection to the marriage by way of caveat by simply writing in the marriage notice book the word forbidden. So the law is that marriage notice book that your notice for marriage was entered, that marriage notice book is open to the public within the office hour. So someone can come and inspect that notice book and all that. And anybody whose consent is required, maybe your parents, one of the parents to be spouse was not informed that their child wants to get married. And maybe she heard it somewhere, or she saw it at the notice board of the registry that, oh, my daughter or my son is about to get married to so person, and I'm not aware of it, and I am the father or I am the mother or something like that. They can come to the registry to inspect the notice book. Okay? Or it might be your ex-girlfriend or your ex-boyfriend that you maybe you paid her dowry in the village and abandoned her, and now you want to come and get married at the registry. Okay? So the law is that anybody who have objection as to why that marriage should not take place can inspect the marriage notice book, and if he has an objection, he can write in that marriage notice book where they write where your name was written and your notice was written. He can write opposite it the word forbidden. Forbidden. That he is forbidding the registrar from giving you marriage certificate. That's what it means. So he can write the word there, forbidden. He or she must also state his name, his or her address, and details of his or her complaints against the intending marriage. So after writing the word forbidden, he's also to write his name, expected to write his address, and expected to give reasons why he is forbidding the registrar from issuing the marriage certificate to you or to the couples and all that. You have to state the reason. Okay? In the case of an illiterate, such objection to the marriage can be entered on his behalf by the registrar upon verbal complaint to him. So if the person who has the complaint or who has the caveat is an illiterate, the law is that he can complain to the registrar. This is maybe he doesn't understand English, he can only speak Hausa, or he can only speak Igbo, or he can only speak Yoruba. He can speak to a registrar or through an interpreter to the registrar. Okay, this is my complaint. The registrar by himself will now help him and write the word forbidden, write his name, write his address, and write the reasons for his objection, his or her objection. You understand? In a situation where a covenant has been entered against the marriage, the registrar shall not issue his certificate, but will first refer to the judge of the High Court of the state, who shall summon the parties to the intended marriage and the person who entered the caveat. So once a caveat is entered in the marriage notice book, once anybody comes to complain by writing the word forbidden in the marriage notice book, the law is that the marriage registrar must not issue his certificate. That couple. He must not issue. The first thing he has to do is to refer that couple or to refer that caveat to the judge, the High Court judge of the state. The registrar must not, under any circumstances, issue the marriage certificate to any marriage where a caveat has been entered until he referred that marriage to the High Court judge of that state. Okay. Now, upon referring that matter to the High Court judge of the state, the High Court judge of that state have to summon the parties to the marriage and also summon the objector to come and explain to the court why the registrar should not issue certificate to that to-be couple. Do we understand that? Now, we had a similar situation like that in court. And the law is that any minister in a licensed place of worship who is aware of any caveat, that is why in a court, in a church, before a marriage takes place, there's what we call ban of marriage. They publish a ban of marriage. They usually publish it like 3 times. Some churches publish it like 3 times. So at every service, they will announce that so and so person intends to get married on so and so date. If anybody have any reason why they should not marry, they should say it now. After the first report, they will tell you this is the first publication. Maybe in the next service, next Sunday, they will publish again. So and so person intends to get married on so and so day. If anybody have any genuine reason why they should not marry, please say it now. This is the second publication. Maybe the third service or maybe subsequent date. They will announce so and so person intends to get married. Please, if anyone have any reason why they should not get married, please say it now. This is the third and final notice. So the law is that if a minister in a licensed place of worship receives any objection why a marriage should not proceed, that minister is forbidden from issuing a marriage certificate to that couple. That minister of place of worship is forbidden from issuing the marriage certificate as in Form E to that couple. That is just for you to know. So we have a similar situation now in a marriage that is contracted at the registrar. So the High Court judge will summon the parties to explain why the registrar should not issue his certificate to be couples. And this is expected to be a summary hearing with right of appeal to the Court of Appeal. So the judge is supposed to be a summary hearing. He said that the judge can just put them forward before they put the objector before the court and ask him questions or ask her questions to explain to the court. So there must not be formal filing of papers, filing of pleadings and all that is not required. The judge will just ask him questions or may put him under oath, ask him questions. Why do you think this couple should not be married? Why do you think the registrar should not issue his certificate to this couple? Explain to me. Okay? And the law is that if after the decision of the court, if the court gives a decision, any of the parties, whether the objector or the parties to intended marriage, any of them has the right to appeal the judgment of the High Court. They can take the appeal to the High Court, even up to the Court of Appeal, even up to the Supreme Court. Okay. So, if the honorable judge is not satisfied with the reason advanced by the person who opposed the marriage, he shall cancel the word forbidden in the marriage notice book and write under it, cancelled by order of the High Court, and shall sign his name thereto. Now, if after the objector explain why the registrar should not issue the certificate to be married to the intended couples, if the judge is not satisfied by that explanation, the judge can cancel the word forbidden from the notice book The judge will use pen, cancel the word forbidden, and write under it, cancelled by the order of the High Court, and write his name and sign there to under it. Do you understand? If the judge is not satisfied by the reason why the person is preventing the marriage from going on, the judge will use his pen, cancel that word forbidden written in the marriage notice book, write under it, cancelled by the order of the High Court, and write his name and sign the marriage notice book. Then what happens then? Upon the cancellation, the registrar shall proceed to issue his certificate as if there was never any objection to the marriage. So once the High Court judge cancelled that word forbidden, the registrar is free to issue his certificate to the intended couples. Okay, so that is all it takes to, give notice, and that's all it takes to get married at the registry. Before the registrar issues the marriage certificate to the couples, he must be satisfied of the following on oath. So, if there was no objection to the marriage, before the registrar issues his certificate to the intended couple, if there was no objection, or if there was any objection and it was cancelled by the order of the court, before the registrar should issue the marriage certificate as informed, registrar certificate is informed. Okay, we'll get to that next. So before he issues that certificate, he must be satisfied of the following under oath. That means there must be an affidavit. The intended couples must produce an affidavit stating the following: that one of the parties to the intended marriage lives within the district of the registry where the marriage is to be celebrated for at least 15 days. So part of the things that they must satisfy the registrar is that one of the parties, at least one of the parties to the intended marriage, lives within the locality of that registry where the marriage is supposed to take place. Okay, so let's say the registry is at Wuse district in Abuja. That registry covers Wuse district in Abuja. So one of the parties to the marriage, to the intended marriage, must state that he's living within Wuse district. But he has been living within the Wuse district within a period of 15 days. We understand that for at least 15 days. Number two, that each of the parties to the intended marriage, not being widow or widower, is up to 21 years old. That each of the parties to the marriage, the exception there is that you are not a widow or a widower. Okay, if you're a widow to widower, that one is not an issue. If you're a widow or a widower, no problem. The law will not look at that. But if you are not a widow or a widower, each of the parties to the marriage must be up to 21 years old. You cannot marry an 18-year-old girl, or an 18-year-old man or boy or young man cannot marry at the registry, except with the exception provided. So each of the parties to the marriage must satisfy the registrar that they are at least 21 years old. Now, note that where any of the parties is below 21 years old, consent must be obtained in writing and attached to the affidavit. Where any of the parties to the marriage is below the age of 21 years old, he must obtain the consent of his parents. If the parents are no longer alive, or if the parents are not in Nigeria, he must obtain the consent of the guardians. If the guardian if he has no guardian or whatever, they can obtain the consent of the governor of the state. I know they can obtain the consent of the governor of the state, consent of maybe a recognized minister of the church, and also there are still other persons that they lost the period. I am sure of the governor of a state. They can obtain the consent of the governor of the state, or a consent from a recognized minister in a recognized place of worship. Okay. Number three, that the parties to the intended marriage are not related by blood or kindred. So you must satisfy the registrar that both of you that intend to marry are not related by blood, they are not related by kindred. That neither of the parties to the intended marriage has previously married to someone else under the custom other than the person intended to marry to. You must satisfy the registrar that you have not married anybody before under the customary law. You must confirm to the registrar that I have not paid anybody bride price before, other than this person you want to get married to. That you have not paid anybody bride price before, or have married anybody under customary law of whatsoever custom and tradition. You must certify the registrar that you have never married anybody under the customary law, other than this person you want to marry. Maybe this person you want to marry, have paid his bride price, no problem. But I have not paid any other person bride price before. You have to satisfy the registrar that you have not done that before under oath. So these are the procedures that you must follow. These are the facts that you must satisfy the registrar before the registrar can issue you the marriage certificate under the act. We understand that. So we are done with that under the marriage at the registrar. This is all you need to get married at the marriage registry. Now let's look at the second one. Marriage by special license. Marriage by special license. Marriage by special license is provided for under section 11 of the under section 13 of the Marriage Act. It is a situation whereby the minister, upon proof being made to him by affidavit that there is no lawful impediment to the proposed marriage, and that the necessary consent, if any, to such marriage has been obtained, may, if he thinks fit, dispense with the giving of notice and with the issuance of the certificate of the registrar, and may grant his license, which shall be according to Form B in the first schedule. So this is a situation whereby a party who wish to get married, first of all, they will advance an affidavit to the minister. Now it's no longer to the registrar, it's not to the place of license, place of worship. This one, you are going directly to the minister, Honorable Minister of Interior. You are sending an affidavit. You just forwarded your affidavit to this affidavit we stated above now, that you must satisfy the registrar. These facts that we stated here, that you have not previously married under the custom, that you are 21 years old and above, and that you live within the vicinity of the registry and all that. But to forward an affidavit, satisfy that there is no impediment, there is nothing stopping you from getting married, you fulfill all the requirements under the law. Forward that affidavit to the Honorable Minister. Now, if the minister, after looking at that affidavit, thinks that, if he thinks fit, he will now dispense with you giving notice to the registrar. And you should not need to give registrar notice again of your marriage. He will dispense with the notice. He will dispense with the registrar's certificate. He will issue you a license in that place. So instead of giving you a certificate, he will give you a license. The minister will give you a license. Now, what will you do with that license? Let's proceed. The minister's license authorizes a registrar or a minister of a licensed place of worship to celebrate marriage for the parties named in the license. So once the minister gives the to-be couple the license, they will take that license. That license will be directed to a registrar or to a minister in a licensed place of worship. So the minister will write in that license and address the license to a particular registrar, or address the license to a particular minister in a licensed place of worship, authorizing that registrar or authorizing that minister to please conduct marriage for this couple or to be couple. That is marriage by special license. That means the minister gave you license, you and your to-be wife or to-be husband, that you should go to a particular registrar or to a particular church or a particular licensed place of worship. Go there and collect your marriage certificate. Go there and conduct your marriage. That is marriage under special license. Under Section 27 of the Marriage Act, after the issuance of the registrar certificate or the minister's license, the parties to the intended marriage may wish to contract the marriage before the registrar in his office in the presence of 2 or more witnesses between the hours of 10 a.m. to 4 p.m. Now, after the registrar has issued you the certificate, his certificate, or if it was a license that was issued to you, When we talk about registrar issuing you certificate, it's a blank certificate. That is what he's supposed to issue. So it's not as if the issuance of the certificate does not mean that marriage has taken place. The registrar issuing you certificate does not mean that you have married. So if these are the requirements, we have stated the requirement that you can meet for you to be qualified to be issued the certificate. So after the registrar you have met all these conditions, and the registrar has issued you the certificate, or after you have satisfied the honorable minister and the minister issues you the license, the next thing for you is to go and conduct the marriage. Now let's look at how marriage is conducted at the registry. That's what we want to look at now. After you must have obtained the registrar certificate, or after you must have obtained a special license from the minister, this is how you will conduct your marriage. Now, the law is that you can decide, after the registrar has issued his certificate, you can decide to conduct your marriage before the registrar, or you can decide to take your certificate and go to church and conduct your marriage. Either way you want. So, in a situation whereby you decide to contract your marriage before the registrar, the law is that you can contract your marriage in the office of the registrar, inside your registrar office. If the registrar go and stay under the tree and conduct that marriage, is not a marriage. If the registrar go to maybe one nearby hotel to conduct that marriage, it's not a marriage. That marriage must be in the registrar office for it to qualify as a statutory marriage. The same way your pastor cannot come to your house to conduct marriage for you, because your house is not a licensed place of worship. The same way your pastor cannot come to your office and conduct your marriage. That is the same way a registrar will not have to leave his office to conduct a marriage. He must conduct the marriage in his office between the hours of 10 a.m., right? Let me look at that. Between the hours of 10 a.m. to 4 p.m. in the presence of at least two witnesses. In the presence of at least two witnesses. Okay, so this is how it usually takes place. Upon production of the certificate or the license before the registrar, upon you producing the certificate before the registrar, or upon you producing the special license to the registrar shall directly or through an interpreter say to the intended couple thus. So this is what the registrar will say, will ask them. Do I understand that you, they will mention your name. Let's say, for instance, Emeka Okeke and Nkechi Okafor come here for the purpose of becoming man and wife. Let me read that again. The registrar will ask them, do I understand that you, Emeka Okeke and Nkechi Okafor, come here for the purpose of becoming man and wife? If the parties answer in the affirmative, he shall proceed thus. So if they say yes, you proceed. Know ye that by the public taking of each other as man and wife in my presence, and in the presence of the persons now here, and by the subsequent attestation thereof, by signing your names to that effect, you become legally married to each other, although no other rites of a civil or religious nature shall take place. You see what the registrar is saying to them? Shall take place. And that this marriage cannot be dissolved during your lifetime, except by a valid judgment of divorce. This marriage cannot be dissolved at any time during your lifetime, except by a valid judgment of divorce. And if either of you, before the death of the other, shall contract another marriage, while this remain always undissolved, you will be thereby guilty of bigamy and liable to punishment for that offense. This is what the registrar will read before. Each of the parties shall then say to the other, I call upon all persons here present to witness that I, Emeka Okafor, do take thee, Nkechi Okeke, to be my lawful wife or my lawful husband. Each of them will say to each other. You understand? So this is all it takes to get married before the registry. Now, but something caught my attention when I was reading this. Now, the registrar said something. He said, and that this marriage cannot be dissolved through your lifetime except by a valid judgment of divorce. Because I've heard some people who married under the law, who married in their church. Anyway, if it is your church you got married, we have discussed that earlier. If you married under your church, yeah, you can do whatever your church say you can do. But if the marriage you contract in your church is a marriage under the act, if it is a monogamous marriage under the act, the law is that you cannot divorce, you cannot separate that marriage unless by a valid judgment of divorce. And some people have said that no, we cannot do divorce in my marriage. There is no divorce. It's for better and for worse. Do you hear the registrar here say for better and for worse? It's only in your church they will tell you for better and for worse. It's only in your church they will tell you in richer and in poverty. When money dey and when money no dey. When I am hungry and when I am bellyful. That's where you will do all that one. Not in the registry. Registry will tell you, say this marriage. In fact, the registrar said that you cannot even that. Look at what the registrar, part of the affirmation of the registry. He said, although no other right of a civil or religious nature shall take place. So the moment you marry before the registrar, you don't need to go and do church wedding again. You don't need, you have already married. The moment you married at the registry, no other civil or religious right is required. Maybe you might just call your pastor to bless you. But don't need to go and do wedding and spend money and do all that. Actually, and do all that. It's more cheaper to marry at the registry. More cheaper. The same thing. Both person who married at the registry and the person who married at the licensed place of worship. The same thing. The only difference is that this person spent more money in doing ashebi and renting a hall to do reception and doing all that. And the other person just gathered maybe one or two of his friends, entered the office of the registrar, did their thing, and that's the only difference. So, marriage before the registry is not for better and for worse. It's a marriage for life. That's the law. It's for life. But there's a room for divorce. And also the marriage you contracted in your church. The same marriage, the same monogamous marriage, the same statutory marriage, there is still a room for divorce. We will come to that when we come to church. When we come to discuss the Bible concept of marriage, we will talk about divorce on that. Okay? And we are going to also talk about divorce under the statutory law. What does the law say about divorce? Because the law created marriage. It is the law that regulates marriage. It is the state that regulates marriage, and not the church, and not the Bible. Marriage is what the state said it is, not what the Bible said it is. It is the marriage, it is the state by the Marriage Act that set the rules for marriage, not the church, not the Bible. I'm going to come to that in subsequent discussion. So these are the oaths that should be taken before the registry, but it's not even an oath, it's an affirmative, it's an affirmation. It's not an oath, it's an affirmation. Once you take this affirmation before the registry, you've contracted your marriage. So thereafter, the registrar shall fill up the certificate by ensuring that the names and signatures of the parties to the marriage are well captured together with his own signature. He shall thereafter issue a copy to the couple and file a duplicate in his office and the record of the same in the marriage book. So after they all say to each other that I call upon all persons here present to witness that I, so person, do take so person to be my lawful wife. Chicken, if they have ring, they can exchange ring. If it's Bible, they can use Bible as the oath for commitment or affirmation. Use it and make this affirmation. If they have a ring, they can use ring. If they have a Bible or anything they want to use to confirm to each other their fidelity in the marriage, they can use it. It's not a must use ring. You can even use, in fact, at the registry, there's a Bible there. You can use Bible. Or you can use anything. If it's your pen, this is your charger cord. You want to use and affirm to your wife or your husband. You can use it and say, I take you as my lawful wife. That's all. Anything you can use it. There's no law that says it must be a ring. There's no law that says you must bring a ring. No law says you must use ring. No law say you must wear your wife ring to be sure you have married him. No law say that. So after all that, the registrar will now collect the certificate and fill it. Fill it your name, fill his own. Make sure that you sign your name. They will date the certificate. He will write his name, sign, date it. Also ensure that the duplicates are in order. He will issue you the original. File the duplicate in his office. Remember the way the minister of the place of worship usually does. The same way. After he issue you the original, he will file the duplicate in his office and enter the marriage in the marriage book. The same way, the same procedure at the licensed place of worship. Because at the licensed place of worship, after you have signed the certificate, the priest will issue you the original and go to the registry to file the duplicate. The registrar will now enter the duplicate in his office and enter the marriage in the marriage book. But this time around, your marriage is taking place at the registry. The registrar will give you the original and file the duplicate in his office and enter the marriage in the marriage book. Once that is done, marriage before the registry has been contracted. So that is all that the law requires from you. Contract a marriage under the law. Okay? So we have mentioned the 3 ways by which you can contract a marriage under the Act. Number 1, before the registry, by special license. Remember what I said about special license. The minister gives you the license. That license directs you to the registrar to conduct this marriage. Or he directs you to a church before a licensed place of worship to conduct your marriage there by that special license. So we say the marriage can be conducted by the registrar through a special license or by a minister in a licensed place of worship. So thank you so much so far. This is where we can draw the curtain for today. Thank you for your time. Thank you for your attention. Please do well to follow my channel, like on Facebook, like on TikTok, like on YouTube. Do well to follow, like, and share.